These AI tools are powerful. Even the legal specific tools should be first drafts, not last drafts. We should take the answer and we should verify it. When I talk about accuracy, I mean that the cases that are cited exist and stand for the proposition, the point of law that they're being cited, right? Retrieval augmented generation, this retrieval step is a revolution. I think it's amazing. The ability to ask the question in plain language and to get all of the documents that really answer the question along with confidence scores.
Welcome and thank you all for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Ed Walters. Ed Walters is the Chief Strategy Officer of VLEX and co-founder of Fastcase, a legal publishing company based in Washington, D.C. Fastcase and VLEX merged in April 2023 to form one of the world's fastest growing legal publishers. Its global law library serves more than 3 million subscribers and includes the laws of more than 110 countries in a single platform. Before founding Fastcase, Ed worked at Covington & Burling, where he advised Microsoft, Merck, SmithKline, and more, the National Football League, as well as other major clients. Ed is an adjunct professor at the Georgetown University Law Center, where he teaches the law of robots, as well as Gen AI and big law, and a lecturer at law at the University of Chicago Law School, where he teaches generative AI in legal practice. Now, the webinar presentation that you're about to watch will be approximately 1 hour, and once that's complete, Ed will be taking questions from the audience. So if you have any questions that come up during the presentation, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen, and we will address those once the presentation is complete. Now, without further ado, here is Ed to discuss practical AI for lawyers, hands-on tools for daily practice.
Wow, thank you, Nina. What a kind introduction. I can skip this slide altogether, which is very useful, and get straight into that kind of practical hands-on tools for daily practice. You know, there's a lot of talk about AI, and I'm obviously an enthusiast for it, but I really want to say I'm against magical thinking about AI. I really want to talk about the very practical things it's useful for, what it's good at, what things it's not good at, and I want to ground the conversation. Like, what are we talking about when we're talking about AI? So to do that, I'll just say, like, maybe at the outset, what is this technology? It feels like magic. There's a lot of kind of puffery around it. And I'll just say, like, for the most part, generative AI is really using a predictive algorithm to figure out how to make the most likely answer to a question. These training models you've heard of, like GPT-4 or Gemini, are trained on language found in books on the web, but also question-answer pairs. So it looks at a bunch of questions and answers and then says, based on a new question, what is the most likely answer supposed to look like? This autocomplete is familiar to those of you who are texters. If you ever have autocomplete suggesting the word ducking, you know exactly what I'm talking about. This autocomplete technology is pretty good, but not great. It got much better in the world of generative pre-trained transformers, or GPT tools. Why does that matter? Well, I want to just maybe take a detour for a second and talk about what came before this, which is the kind of reinforcement learning or training model where you would train computers to do a very specific task. And after training it a lot, you would be able to do that task. This is the same technology that powers electronic discovery. My favorite illustration of it, though, is Google QuickDraw. This is from about like 2017. It's a little bit early. It's an experiment from Google. The best way to describe it is like kind of a left-hand, right-hand algorithm. The left hand tells you draw animal migration in under 20 seconds. The right hand doesn't know what that is. Based on the doodle, it will try and guess what you're drawing, right? So I'm going to use my mouse on my computer. I'm not a great artist. I'm going to try and draw animal migration. This is a really hard one. And then, Quick Draw is going to try and guess. All right. All right, here we go.
I see knee, or mountain, or table, or bench, or bridge. I see mouse, or satellite, or mailbox, or arrow. I see stairs. Oh, I know. It's animal migration.
What? All right. Okay. Draw a car in under 20 seconds. I think this will be
I see
easy.
suitcase, or
Migration.
squiggle, or shoe, or the Great Wall of China. Oh, I know. It's car.
All right. Gosh, draw a toilet in under 20 seconds.
I see golf club, or moon, or banana, or potato. I see helmet, or boomerang, or garden hose, or snail. Oh, I know. It's toilet.
All right. Draw a fence in under 20 seconds.
I see leg, or square, or seesaw, or lipstick, or crayon. I see marker, or pencil. Oh, I know. It's fence.
All right. Draw a carrot in under 20 seconds.
I see line, or nail, or green bean, or ice cream. Oh, I know. It's carrot.
All right. Draw a tiger in under 20 seconds.
I see line, or ocean, or green bean, or knee. I see drill, or springboard, or table, or megaphone. I see rhinoceros, or bed, or horse, or dog, or dragon. I see zebra. I'm stumped. Sorry, I couldn't guess it.
All right. That's a little bit embarrassing. All right. So what's going on here? Based on these crappy doodles, how is Google guessing what I'm drawing? Well, the reason is it is looking at the world's largest doodle data set. It has more than 50 million drawings. And so when I say, draw a tiger or an octopus, it has like this training set of 143,000 octopi that it can draw from. And it looks at how people start drawing these things. And so, based on this, the algorithm is trained to recognize certain things, even the way that you start to draw it. And so, we're going to take some illustration of how we would draw a tiger. Oh, those are much better tigers. Um, and so, Google Quick Draw has this training data, right? And so, in the old world of AI, this training data is how you would tell AI to do something. So, I guess the metaphor is the reason that generative pre-trained transformers are so much better is that in order to produce like an English paper on the Great Gatsby, you don't have to have 100,000 English papers on the Great Gatsby. Generative pre-trained transformers are trained on the entire world of language. Maybe some copyrighted too. I'll put that to one side for a second. But the revolution here with GPT tools is that we don't have to train them with a giant doodling data set. It's trained by all of the language that these models can access. And these general foundation models, you're familiar with them, OpenAI, the maker of ChatGPT, Gemini from Google, Claude from Anthropic, Llama from Meta. These are sometimes called foundation models, right? Very powerful. And, I think we've seen from ChatGPT, revolutionary. They really kind of changed the game. In fact, many people believe that these are going to be a fundamental change in law. If you look at this Goldman Sachs study from 2023, they believe that law is going to be one of the most impacted areas. You can sort of see here, Goldman Sachs thinks that 44% of legal tasks could be automated by AI. Let me make an important distinction here. Not 44% of legal jobs, 44% of legal tasks. which is fundamentally different. But look, I mean, we're on the side of the spectrum where there's going to be a lot of task displacement by these tools. The Clio Legal Trends survey, one of the best studies on the market of legal work, is pointing out the specific tasks where automation and generative AI will be the most transformative. Um, preparing legal documents, preparing documentation about legal proceedings, getting information like doing research and evaluating findings. These are very ripe for automation. And so I think we're seeing this big transformation in the market for legal services. We should talk tangibly about what kinds of things we can do with it. And I think also maybe the risks. And I'll talk about the model rules a little bit as well while we're talking about responsible and ethical AI. So when I talk about the risks of general models, the place you're required to study, if you talk about this, I think, is Stephen Schwartz and Mata versus Avianca. But I want to talk about this kind of like a lawyer and not like the New York Times. So let me start with law professor mode. I'll state the facts of the case. Mata versus Avianca. So Roberto Mata is flying from San Salvador to New York on Avianca Airlines in 2019. And during the flight, the beverage cart breaks loose, hurtles down the aisle, smashes him in the kneecap. He's on a 7-hour flight, and he's in agony. The plane lands in New York at the end of 2019 after 7 hours. He goes to a doctor to try and get help. The doctors can't ever really fix his kneecap. And they're spending months trying to get it right. They can't do it. But there's an intervening event because, as we all remember, soon after this event in early 2020, we have the global coronavirus pandemic. And suddenly, his kneecap kind of takes a back seat to this global pandemic. He can't go to the hospital. He can't really do anything. Everyone is locked down. Fast forward to 2023, when Mr. Mata goes to a lawyer named Stephen Schwartz to say, help, my knee's never been right. I would like for Avianca Airlines to pay my medical bills and compensate me for my pain and suffering. Stephen Schwartz says, look, I wish you would have come to me in 2021. We are now like almost 4 years after the event of this accident. The statute of limitations likely bars this. When you sue airlines, it's kind of a global treaty that was signed. It's the Montreal Convention saying when you can sue global airlines. So you're not doing choice of law all the times. But the Montreal Convention says the statute of limitations is 2 years. But Stephen Schwartz dimly remembers that there's a provision of bankruptcy law that says that the limitations period is tolled. It pauses during the duration of a bankruptcy. And in fact, Avianca Airlines had declared bankruptcy during the COVID pandemic. So he sees the opening. Now all he has to do is make that point. Now, it is early 2023. Travel back with me in the time machine. People in webinars just like this one have been telling Stephen Schwartz for a couple of years in 2023, AI is not going to take your job. Lawyers who use AI are going to take your job. Stephen Schwartz wants to be the lawyer using AI. What tools does he have? Does he have Vincent AI from VLEX? No, doesn't exist yet. Does he have Lexis Plus AI Protege? He does not, doesn't exist yet. Does he have co-counsel from Thomson Reuters, then Case Text? No. What does he have? Well, he has this brand new tool called ChatGPT, which had launched a few months earlier. So Stephen Schwartz, trying to use AI, types into ChatGPT, like does the statute of limitations toll under the Montreal Convention for the duration of a bankruptcy. ChatGPT comes back to him and says, Stephen Schwartz, you are in luck. The law is exactly as you wish it to be. The limitation period does in fact toll under the Montreal Convention during the duration of a bankruptcy. Here is a case that stands for that proposition. Is Farghese versus China Southern Airlines Company Limited. Here's the citation for it. And here's a very helpful quote, the winning quote from that case that helps you establish this tolling provision. Now, look, in hindsight, we have red flags going off everywhere, right? We are paranoid about this tool hallucinating. We're really worried about it, right? But again, we're in our time machine. It's early 2023. The term hallucination doesn't even exist. We have the benefit of this article from the New York Times. Stephen Schwartz does not. And I want to say with some sympathy for Stephen Schwartz, like, what's the alternative for him? At that time, the way that you would do this is you would use a search engine like Fastcase or VLEX or Westlaw or LexisNexis. And you would imagine what language a court would use. And you would put together a Boolean expression to find that tool. And you would say this word within 4 of this other word, and this synonym, or this synonym, or this synonym, and this exact phrase. Even with the best tools in the world, like Justia or Fastcase, that is the state of the art, right? Boolean is the best you get. And your reward for doing this is a giant list of documents, most of which are irrelevant, that may or may not include the case or statute that you're looking for. But you can't find that out without reading like hundreds or scores of documents, right? This is not great. So by comparison, when Stephen Schwartz asks this question in natural language to ChatGPT and gets this amazing, beautiful, structured, cited answer, he's got to feel like this AI stuff is amazing. Like this is way better than those old Boolean searches, even on cool services like Justia or Fastcase, right? So we all know what happens next, I think, right? So this is kind of where I get off the train with Stephen Schwartz, because what he does is he copies that citation and the quote and pastes it directly into the complaint, establishing that the limitation period hasn't run. And the opposing party writes to the court and says, hey, I've got a little problem because I can't find this case, Farghese, or these other cases that are cited here. And the court writes Stephen Schwartz back and says, hey, we can't find those either. Now, at this point, I think if Stephen Schwartz had fallen on his sword, he'd be okay. But that is not what he did. Did he open his version of Fastcase that is available to him as a member of the State Bar, the New York State Bar Association, to verify these sources? He did not. Did he log into Justia to see if he could find these cases? He did not. Friends, he went back to ChatGPT. This is actually an exhibit from the sanctions decision by the court. You can see the Pacer stamp on it. Yes, he goes back to ChatGPT and he says, is Farghese a real case? ChatGPT helpfully says, yes, Farghese versus China Southern Airlines Company Limited, 925 F3rd 1339, 11th Circuit 2019 is a real case. And by the way, marvel with me for a second. This is a really pretty good citation, right? I mean, it's using the table 6 abbreviations from the Blue Book. I would want, periods after company and limited here, but it's a good citation. The F3rd reporter was in roughly the range of 925 in 2019. The 11th Circuit is an actual court that is reported in the F3rd reporter. Page 1339 is like within the range of pages for that book. It's not page like 3009 or something. Or page 6. It looks like something that could be in the range of the Federal Reporter for an 11th Circuit case, right? This is pretty good. And again, the red flags, like now we know it's auto-completing. It's trying to put together a statistically likely answer, not a correct answer. It's a sycophant. It's trying to please him. So he wants this case to exist. ChatGPT is happy to oblige, right? Um, Stephen Schwartz is not done yet. He's no dope. He says, "What is your source?" ChatGPT, I apologize for the confusion earlier. Upon double checking, I found that the case of Varghese versus China Southern Airlines Company Limited, now with the periods, does indeed exist and can be found on legal research databases such as Westlaw and LexisNexis. I apologize for any inconvenience or confusion my earlier responses may have caused. Look, in 2023, if I'm reading this, I would think that this AI tool checked once, not once, but twice. It double checked. It looked in Westlaw, it looked in Lexis, and it found this case. It says so. Look, in Stephen Schwartz's whole software life, if software doesn't know the answer, you get a 404 error. You get a file not found error. If you run the search in Justia and there's no results, or in Fastcase or VLEX and there's no results, it comes back and says no results found, right? This is the first time ever when there's no real answer, where it doesn't find the result, that it says, not I can't find the results. I have found the results. And I'm telling you that you are absolutely correct. Are the other cases you provided fake? He asks. No, the other cases I provided are real and can be found in reputable legal databases such as LexisNexis and Westlaw. Oh, Stephen Schwartz. I mean, the guy should win like a Nobel Prize just for being the negative example and the warning for the rest of us, right? What's going on here? Well, these foundation models are not truth engines. They are not AI that is looking into a database of results to try and find the answer and report it back. They are looking at the universe of questions and then comparing this question and trying to, word by word, create a statistically likely answer, if not a true or correct answer. And it's very convincing. I mean, this is a design choice by the foundation models, but they're extremely confident. All right. So that brings me to like kind of the hallmarks of responsible and ethical AI. I'm going to talk about the model rules of professional responsibility for a second, but I want to say, the hallmarks of these for me are accuracy, transparency, and confidentiality. These are the cornerstones of ethical and responsible AI. Look, for the food that we eat, we require that there be ingredients and nutrition labels. We want to be informed consumers. Shouldn't we demand the same thing for the legal information that we consume, right? So I'm showing you Vincent AI from VLEX. It's obviously not the only legal specific tool for this. There is, Protege from Lexis or Lexis Plus AI. There's Co-Counsel or Precision from Westlaw. Vincent AI from VLEX isn't the only one of them. It's just the best one. So look, when I talk about accuracy, I mean that the cases that are cited exist and stand for the proposition, the point of law that they're being cited for, right? Accuracy in the sense that you are using a tool that is designed to go find the law and then report it back to you. And I'll talk about this a little bit more, but you can see with Vincent AI, we dedicate like half the screen to the sources. We're really searching in the database for documents that will answer the question: judicial opinions, statutes, secondary treatises, administrative decisions, things like that we can actually use to create an answer that is grounded in law. But more than anything, you can see the ingredients that go into the answer. With a lot of generative AI, you ask the question, something magical happens in the background, and then an answer gets spat out the other side, and you don't really have a good way to verify it. One thing I like is the foundation models now are trending towards citing their sources. And I'll talk a little more about this too, but One service I didn't mention before that I'll mention here is Perplexity AI, which does something like this. It finds sources and answers questions. The legal specific domain tools are designed to be more like fact engines. They're designed to find the law and then use that law to create an answer. They're searching over a database of the law to make an answer that is verifiable. And at least you can sort of, in a way that is accurate and transparent, you can see what's happening here. How does this intersect with the model rules and ethical and responsible AI? Well, Rule 1.1, the duty of competence, and in 37 states now, Comment 8, the duty of technological competence, basically says that competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Do you have to be a computer scientist? No, but you have to know what the tools you're using are good for and what they're not good for. And I would say you have to have transparency into those engines. You have to be able to understand, what they're good at and what they're not good at. You have to be able to see, transparently what is going on behind the scenes, and you have to make sure that, the tools are designed for the kind of work that you're putting them to. This is hard. I mean, the Gen AI models are changing a lot. But I'll point out this is very similar to e-discovery in the sense that right now it's kind of an optional thing. As the new benchmarks are coming out saying that it performs as well or better than human lawyers, this may become a mandatory thing in the future. Rule 1.1 probably requires for big document productions that we use e-discovery instead of an army of paralegals and lawyers going through warehouses. The same thing will likely be true in the future for some, but not all generative AI tasks. Rule 1.3, duty of diligence and zeal. If you can do it faster and lower cost with generative AI in a reliable way, you might be required to do it. And then confidentiality. We need to make sure that the models we're using aren't training on those question answer pairs, that we're not inadvertently releasing client confidential information into these foundation models. Now, I'll just point out this is another difference. For the general foundation models, many of them, the default is to train on your queries and your answers. For legal specific AI, they're all using lockdown versions, so they're designed to be bank grade security. Nothing ever gets trained on the question answer pairs. At least that's true in the one we're building at VLEX. Vincent AI is very highly locked down, bank grade security. Nothing ever gets trained from those queries. Stephen Schwartz might be the poster child for this, the duty of candor to the tribunal. In addition to citing hallucinated sources, when he went to go confirm these sources with ChatGPT, instead of going back to the court and saying, I couldn't find the whole case, he cut and pasted segments of the answer from ChatGPT into a Word document and tried to format it like a judicial opinion and pass it off as an opinion to the court. Obviously, the duty of kin to the tribunal would forbid that. But I would say just in general, too, like you have to represent to the court that the things that you're citing actually exist and that they stand for the point of law that you are citing them for. I think that's table stakes. I would point out that, candor to the tribunal also means that you are straightforward and direct with the court about what tools you're using. Some courts require with standing orders that you acknowledge when you're using generative AI tools. And so that also reads onto this as well. At the very least, if you remember nothing else from this presentation, when you sign a pleading before a court, you are attesting that everything in there is true and correct, including the citations of what you're citing them for. This is not a generative AI rule. If you asked an associate that question or a paralegal and they came back with an answer that looked like a ChatGPT answer, in the age before generative AI. And they said, here's what the answer is, here's the citations. It doesn't matter if you delegated the task. You are ultimately responsible for verifying all those citations. And it's equally true with generative AI. So the buck stops with the person signing the pleading, and that is very much true with Rule 3.3. And then finally, to not put too fine a point on that, Rule 5.3, responsibilities regarding non-lawyer assistance. I don't like the term non-lawyer, but Rule 5.1 says you are responsible for the work of other lawyers in the matter. Rule 5.3 says you're reliable for the rest of the team as well. Legal assistants, paralegals, secretaries, law librarians, and yes, almost certainly software. And the idea is the person signing the pleading can't delegate out the responsibility. She's responsible for everyone who worked on the matter. And when she signs the pleading, she is saying, I have myself verified that all these things are true. Big point too from this presentation, by the way, we don't need new rules, in my opinion, to regulate the use of generative AI. These model rules, Rule 1.1, 1.3, 3.3, 1.6, 5.3, are general rules for legal practice. They existed before generative AI. They do a pretty good job of telling us how to responsibly use generative AI. If you are nerdy about this, I wrote a kind of a law review article about this in 2019 before ChatGPT, talking about how the model rules regulate the use of AI, and it holds up pretty well in the post-GPT world. Why am I drawing a distinction between the foundation models, the autocomplete models, and legal specific AI? Well, this is part of understanding what the tools are good at and what they're not good at. The reason the legal specific tools like Vincent AI or CoCounsel or Protege are better is they're using a process called retrieval augmented generation. It sounds technical and fancy. It's really not. It really means that we're breaking up the task into 3 pieces. And I'll explain it, I hope, in a non-technical way that makes it more accessible. Let's first start with retrieval. When I ask a question of generative AI, in this case, like a bankruptcy question, the first step for legal specific tools, and again, I'm showing Vincent AI, it's not the only one of them. They all sort of work the same way. The first step is retrieval. This is kind of like doing research the same way you would do it, before. You are looking for a list of cases and statutes and regulations and secondary treatises that really answer the question. Okay. Now, here's the key difference. Vincent AI is not using the Boolean search. It's not getting a list of all the documents that use the magic word that you said. If you look at the question here, I'm asking the question in plain language. Permission to put my nerd hat on, but just for like a minute, okay? Everyone's excited about the generative AI part of this and the generation part. I am most excited about the retrieval part. Building these search engines, the fast case for 25 years, this is the real revolution for me. This uses a technology called a vector database. And what a vector database does is instead of indexing all of the words in all of the judicial opinions and statutes, it's indexing the ideas. It's going through each document and saying, what are the big ideas you need? It's kind of like West's headnotes. If you open one of the old dusty law books and look at the headnotes on top, it says these are the maybe 7 concepts in this judicial opinion. Vector databases, we're not obviously using the West headnotes, but it's a similar concept. It will say like there are 7 big ideas in this judicial opinion. And what a vector database does is when it indexes them, it says like all of the same ideas go into this little node, and it creates a map so that very similar concepts are close together. Concepts that are really different are very far apart. But at the end of this process, you have something akin to like a map of the law, where concepts that are similar are close together, concepts that are different are really far apart. But it is a kind of a universe of thinkable thoughts about the law, which is amazing. It's so cool. So that allows us, when we're using generative AI, to take this question, this bankruptcy question, and pull the idea out of that. We index this question vector and then we place it on the map. And then what we're doing is we're saying, find all of the documents that have this identical concept that are about the same thing. And then find all the things that are next to it and all the things that are cited by it and all the things that cite to it, and look at them one by one. Okay. And it takes about 2 minutes, but it will review 200 judicial opinions and 150 statutes and, 3, secondary treatises or 20 secondary treatises, and then decide, like, are these relevant or not? Okay. And then at the end of that, you come up with a list of all the results that really help answer the question. In this case, there are 31 of them, 18 cases, 3 statutes, 10 secondary treatises. I think if you ran like a Boolean search, a terms and connector search, and ended up with, 7,000 search results and read them all, hopefully you would end up with like these 31 authorities at the end of that process, right? All right. For each one of them, you can see like the name of the case, the name of the statute, the name of the treatise. They're all blue because they're hyperlinks, and you click it, you can open it and read it and verify it for yourself. After that, there's a summary and a confidence score. How confident are we that this helps answer the question? Last but not least, there is an exact quote from this document. This is not generated. It's not generative AI. This is just pulling these relevant documents and the exact quote from that document. Fundamentally different. This is where the transparency comes in, the accuracy comes in. One other thing I'll add, 2 other things I'll add. You can see at the bottom that the citator is included in here, very important. And then the other one I'll mention is that at the top right, you see this modify list thing. We can read these and say, look, just like our legal researcher would, I want to use the Williams case, but not the Smith case. And you can change what ingredients go into the gumbo of your answer. And I like that. I think the human judgment here is super important. I want people in the loop. I want people to use their independent judgment to decide how to create those answers. Retrieval augmented generation, this retrieval step is a revolution. I think it's amazing. The ability to ask the question in plain language and to get all of the documents that really answer the question along with confidence scores. After years of trying to figure out how to rank the most relevant results at the top of the list, this is amazing. I'm blown away by it. Okay, so that's retrieval. Let me talk about augmented generation. So the augmented step, this is guardrails behind the scenes that you never have to worry about, but that our team sweats all the time. The augmentation says, look, when you're creating the answer for the judicial opinions, use the majority opinion, not the dissent. Don't use cases that the citator has identified as being overturned. If you're in a civil law jurisdiction, prioritize the statutes over the cases as authoritative. If you're in a common law jurisdiction, do it exactly the opposite way. Hyperlink your answers to verify. So all these guardrails behind the scenes, this is like the augmentation part. Use these documents and only these documents to answer the question. It's all the rules that keep this safe. And then the last step is generation. We use the specific retrieved documents and all those guardrails to create an answer. In this case, which I love, this was actually a question presented in a recent First Circuit case. I'm testing it because I know the answer. I have read the opinion in the First Circuit case, so I know what the answer to the question is, so I can verify it. And the generative AI tool, Vincent AI, actually comes up with the exact right answer. It takes about 2 minutes. All of the sources are hyperlinked. I can verify all of them. And man, when I compare this to the way we used to do it, this is amazing. I mean, not amazing because we're building it. I think it's, I would tell you where there's limitations, but compared to the way we used to do this, this is a real revolution, right? I mean, this is practically speaking, like way much better. To put it slightly differently, when I was a young lawyer 25 years ago, when we had document production for diligence, for discovery, we would literally go on site and collect just thousands of cardboard boxes of paper and then review every sheet of paper in those boxes one by one. It seemed like the right way to do it. It was fumbling around. It was terrible. Like the accuracy and recall of human review is really bad. Okay. But that was the way we did it. We don't do it that way anymore. We don't miss it. It seems now like an anachronism. That fumbling around seems entirely unnecessary. Now I think about all of the times, even today, when clients bring questions to us and we spend some number of hours or days just fumbling around, trying to figure out what the law is. How do we even answer the question? What's the right authority here? Is it going to be a statute or a treatise or a case? Has the court even decided questions like this before? Is there a split in authority? What's the right answer? We spend all of this time figuring out the answer. We're not going to do that anymore. It might take a little while for these generative AI research tools to distribute across us, but it's certainly going to work just that same way. We're not going to fumble around anymore. So our time is going to be spent drafting, advising, thinking about what the right thing to do is in the context of a good understanding of the law. At least that's the hope. All right, so I've got a couple of examples here. I mean, I can show you, maybe in slides. If there's time at the end, maybe I can show a couple of live examples of this, like I did with QuickDraw. Hopefully my work in generative AI is better than my work in doodling. But here is I showed a research example before. Let me show a contract example. So if I go to Vincent AI and I upload a contract in PDF, this is an asset purchase agreement, right? And it's a PDF. So Vincent immediately recognizes this as an asset purchase agreement and says, all right, for this kind of contract, what sort of things would lawyers do? And we're doing this behind the scenes. You can ask anything you want. You can, sort of make an individualized demand at the bottom. But concretely, these are the steps lawyers would do. Like pull all the definitions and make sure they're right, find inconsistencies or ambiguities. I represent maybe Garden City Hospital. Show me the provisions of this that are adverse or hostile to my client. Help me mitigate risks. Help me identify at the end of the process all the post-closing obligations, right? So these are the kinds of things that you would do maybe at the closing of a contract or during the negotiation of a contract. But Vincent AI sort of does them out of the box. If I say, give me a list of all the post-closing obligations, typically there's not like in the contract, like a section that says, here are the post-closing obligations, bang, 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 bang. They're from all over the contract, right? And so Vincent goes through just like an associate would in a closing binder and say, I've identified all of the post-closing obligations. Here's what you have to do at the end of this process. And instead of taking, a week or 4 days or 2 weeks or whatever, it takes about 90 seconds and particularized for each individual contract. I'll point out as well, like if you look at this, in addition to these kind of standard things that you do with the contract, Vincent also has read the contract and said, what legal issues are proposed here? So the two questions at the end, like what are the necessary regulatory approvals required for a hospital asset purchase in Michigan? Man, we didn't even think about this. Like, hey, we're purchasing a hospital. There might be some regulations that govern this. We should take a look at it. What are the legal obligations and potential liabilities associated with assuming a frozen pension plan in Michigan? I mean, this is good issue spotting, right? And hopefully, like good associates or partners would spot these issues in the APA. But Vincent AI does this right off the bat. Okay. Point three, I'm sort of giving you notes about what's going to be on the test. The biggest point three for me is these generative AI tools are powerful. They should be first drafts, not last drafts. Let me say that again. These AI tools are powerful. Even the legal specific tools should be first drafts, not last drafts. We should take the answer and we should verify it. We should take this list of post-closing obligations and go compare it against the contract, right? They're not designed to replace legal work. They're designed to throttle the first 50 to 60% of legal. We will obviously still have work to do at the end, and that's a good thing. I don't consider legal work to be like an event. I think of it like a chain. There are a number of different tasks when you are closing out a contract, creating a closing binder, and advising a client. When you receive a complaint, there's a number of different tasks that you undertake. These AI tools are not supposed to do all of those tasks. They're supposed to do the ones that are the most burdensome, dull, dirty, and dangerous, the places where we're likely to make mistakes or burn a bunch of time for no good reasons. But the last links in those chain should always be human judgment. That's why transparency is necessary. So humans at the end of the process, lawyers can say, I'm going to now use my judgment to say, in light of that, figure out what the law is. I'm going to find out right away what the law is. But then once I find out what the law is, I have the independent judgment to say, here's what we should do about it. Right? All right. Example 2, litigation. If I upload a complaint, here the lawsuit that Elon Musk has filed against Sam Altman and OpenAI. Again, Vincent identifies right away this is a complaint for a breach of contract and other claims. Vincent says, okay, with a complaint like this, here's the kinds of things that an associate would do. Pull out all the claims, create a timeline of the facts, give me defenses for each one of the claims in the complaint. Find matters like this that are pending before courts. And again, like at the bottom, some specific questions that are drawn from the complaint itself, legal questions. What are the legal standards for promissory estoppel in California? We're asking this question because promissory estoppel is one of the causes of action in this complaint. What are the elements required to establish a breach of fiduciary duty? This is going to be really important. What constitutes unfair competition under this section of the California Business and Professions Code? And so we can ask anything we want, but Vincent's going to suggest a few things that lawyers would do in a situation like this. And if I say, give me the defenses, you'll see Vincent says like, okay, here are each individual claim in the complaint, where the governing law is, and then what the defense to that cause of action is. And again, this isn't a guess, this isn't generative, this is pulling this out of this giant database of structured law that Fastcase and VLEX put together over the last 25 years. And we'll even pull like from the complaint itself facts that would help make this defense. I mean, obviously, you want to talk to the defendant as well, your client, to maybe put together a questionnaire. That's one of the tasks you can do. But even some of the facts in the complaint will point to defenses that you can make. And for all of this, you sort of get in the software. You can export it also into an Excel spreadsheet for presentation to someone else as well. And I showed you already the kind of research question that you can do with legal research. This is a search for federal law, but you can do this in any state. The VLEX Vincent AI tool is built on top of the Fast Case Legal Research Database, which we put together painstakingly over 25 years. It's also built on top of the VLEX database. I don't know if this is a common use for people on the webinar, but VLEX is a database of more than 110 countries' laws. And already in Vincent, we have 17 countries. Off the top of my head, the United States and all 50 states, obviously, UK, EU, Ireland, France, Spain, Portugal, Italy, Mexico, Colombia, Chile, Hong Kong, New Zealand, Ecuador, Singapore, Brazil. I might be missing one or two in there, but it's a very extensive. Mexico, obviously, it's a very vast database of law, and you can do comparative research, right? I mean, one of the things I like about the Vincent AI tool for American research is out of the box, you can do a 50-state survey. You can ask a question across all 50 states. You'll get a research memo just like this for each of the 50 states. But then it gets rolled up into a single answer in a table showing what the law is for all 50 states. And if you ever had to do this as a research associate or for a client, it is a humongous pain. It's a terrible exercise. It takes months to do. I still have like kind of emotional scars from doing that as an associate. But now we can do it kind of out of the box, which is amazing. All right. Maybe just a few closing points here. So first, it's early days. These tools are just getting better. This is the dumbest and slowest and priciest that these tools will ever be. I will point out that, as the Goldman Sachs report says, this might take some of the links in the chain. It might replace some of the legal tasks that we do. I don't think it's going to take a whole lot of jobs. The best metaphor we have for this in history is e-discovery. We used to have armies of lawyers who did e-discovery tasks. When those tasks went away, the jobs didn't. We actually have more lawyers today than we did in the age before e-discovery tools. Point two, Javon's paradox, which says that when you lower the price for something, people consume more of it. Maybe that's obvious. So maybe the number of tasks for lawyers, the number of hours decrease, but as the costs of matters decrease, more people will use these services. And that's great news because every access to justice study that's ever been conducted tells us that only about 20% of people with legal problems are addressing them with our help. So if we can reach into that latent market and help more people, there's the potential that we could make more money, that we can be more profitable, that we can do more good, we can be happier. We do less drudge work and less fumbling around. I do think that this will require us to train associates differently. Just like we used to train associates doing this grunt work of document production, and we don't anymore, or at least not in the same scale that we did in the paper discovery world. Some of the research and writing grunt work that we used to train lawyers will likely be done by generative AI. And so we have to find new ways of training those young lawyers and law students. And last, we might need to rethink the relationship between corporate legal departments and law firms. I think it's obvious companies will also adopt these tools, hopefully responsibly. And so it sort of changes which of these tasks they will bring to law firms and which they will do in some other way. With these futures, though, I think there are also really interesting opportunities. I think that this is an interesting opportunity for small firms and medium-sized firms to exert new kinds of leverage. So, for example, instead of filing one class action that a company can defend, you can file 10,000 small claims court cases and do it at scale with the benefit of generative AI. This is an opportunity for us to change the business model. Instead of doing billable hours, we might be able to use generative AI to do fixed fee services. And I think the first firms that are able to do that effectively are going to take an enormous amount of business from billable hour firms. And then finally, as I said before, it's a great opportunity to do scaled work into the latent market for legal services to help people who have not been helped before and to help them at scale. The kind of money per matter might be less, but there might be vastly more matters that we consider. All right, I ran just a little bit over. I'd be happy to take some questions if you put them in the Q&A. I see John Mayer says at the end of the day, is using a legal LLM just a significantly better search engine. You can't completely trust the results, but you are closer to finding an answer in less time. You still have to verify the research, though. I think that is a very crisp way of making the point I did in a duller and more boring way earlier. But yes, at least for the research task, right? I mean, there's 22 workflow tools in Vincent. They're not all research, but for the research task, a legal LLM is just a way better search engine that will also draft like an early answer for you and synthesize, those results. And absolutely, first draft, not last draft. You really do have to verify the research. All right, CC Goen says, in the beginning, you began to say ChatGPT was trained on copyrighted material. Can you explain what you meant? Oh man, that is like an entirely other hour-long webinar. But let's just say ChatGPT was trained on crawling the entire web, crawling Google Books, crawling the New York Times, crawling everything it gets its hands on. Some of that is copyrighted. And there's lawsuits, dozens of them right now, trying to establish the copyrightability of that training data. Some people think that it is copyrighted and should be removed. Some people think it's fair use and a transformative use under copyright law. The Napster case suggested that it's copyrighted and must be removed. The Google Books case suggests that it's transformative use and fair use. So stay tuned. I don't think we really yet know the answer to how people will consider that. Okay, someone says, what are some good first steps for getting team buy-in when you're introducing AI to a more traditional legal environment? Man, I think the big thing here is to be the early adopter and to just show them concretely the way I did, like, use the tools, use them responsibly, and then show them the results. Compare doing it the kind of manual way with a new way. Take a complaint that you receive and run it through one of these tools and just show how much better the responses are, how much faster they are, and how much you can keep your opponents on their heels. You don't need to suddenly ask for the extension of time. You turn everything in early, in fact, and keep the other side running. What about parallel search? Love it. Parallel search was a pioneered invention by Casetext, now acquired by Thomson Reuters and ground into little tiny bits. Thomson Reuters, I think, just took parallel search offline like last week, closing off the Casetext site altogether. But the idea of parallel search was you take a concept and Just type the proposition you're trying to prove into the search box and then get a bunch of documents that make that point. I think it's exactly the way the research tool I was just showing worked. And I think you'll see that in the legal specific AI tools. How do you balance using AI for efficiency without risking over-reliance or missing key nuance in legal work? I would say I work with generative AI the same way I work with associates, which is to say that you always have to come back behind them. You always have to go verify it for yourself. There are people who say if AI doesn't do 100% of my job, then it's not worth it to me. And I think that's obviously, that is one point of view. But I will say you can make the same argument about associates, right? If I have to review the work of associates and give them feedback, it's not worth having an associate. Obviously, for most people, having software do 80% of the work very quickly and having to go back behind it and clean up or exercise human judgment at the end of the process might feel like a good value. How do we explain AI to clients who believe that the use of AI should lower their legal fees? Um, I think clients would be pretty enthusiastic about that. And it might lower their legal fees. It doesn't have to, though. I mean, so one thing that, innovative lawyers are doing right now is saying, let me look back at how much it cost me to do like a no-fault divorce, when I was billing by the hour. Now I'm going to do it for a fixed fee. And I'm going to take a little bit of risk there, but, as long as I price it right, based on history, if I can use AI to do it faster and more efficiently, that just makes me more profitable. I think a riff on that question might be, how do I explain to clients that I'm not using AI when they expect it? When AI might be useful to do this faster and more efficiently. And I think that's a much harder conversation than saying to a client, I'm going to use AI and I'm going to exercise my human judgment at the end of it. I'm going to use it like an associate. I'm going to do it in a way that's transparent and responsible. All right. I love this question from Amari Cruz. Does Vincent dispense with the need for Lexis or Westlaw? Yes. Myra Rosa Pagan says, what cautions should there be on uploading real info and documents with sensitive or private information use platforms? Concern on confidentiality? Absolutely. Yes. Exactly the right question to ask. So for ChatGPT, for Gemini, for Claude, there are subscription models of those that you can subscribe to keep your documents or queries confidential. I personally wouldn't do it, but you could do it if you do your diligence. The legal specific tools like Vincent and CoCounsel and Lexis Plus Protege are zero trust, locked down out of the box. They never share that information. They're designed, I can't speak for the other ones. Vincent is designed to be SOC 2 compliant, bank grade security, more secure than having it on your computer. Never training with those documents, never releasing them anywhere else. It's designed to be very, very locked down. What's the biggest key difference between Vincent and Lexis Protege? I would say that they each probably have their individual strengths. The benchmark tests are just coming out now, so you can see which one's better. TLDR for the legal research parts of it, Vincent is comparing very well versus Lexis Protege. I'm sure there are tasks that Lexis is quite good at. I have no idea what they are. For Vincent, I'll tell you, there's 22 different workflow tools, very good at working with contracts or collections of documents, international, which is unique to Vincent. 50 state surveys and comparing jurisdictions are a strength for Vincent. Lexis Protege, if you have a Lexis subscription, it's probably relatively inexpensive for now to add Protege. So there is that. And I'm not knocking it. I think it's a pretty good service. So it might just be a matter of taste, like search engines. Any features like Clear Brief to verify case law? Yes. And in fact, Clear Brief's verification is powered by Fastcase and now VLEX. So it's very similar. We are going through and hyperlinking every one of those documents, maybe even differently from Clear Brief, because Clear Brief is starting with the case and trying to find the stuff. Vincent is starting with the documents and cases and statutes itself, and creating documents from that. But yes, I think Clearbrief is great because it has that transparency and allows you to see what's being cited and verify it for yourself. Vincent does something very similar.
Thank you so much, Ed, for all of your insights and answering our audience questions. And thank you all so much for submitting your questions. We want to thank you all for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities through select live and on-demand webinars just like this one, helping you stay informed and meet your requirements. Plus, as a Pro member, you can enjoy an enhanced directory profile, the AI-powered Justia chat to capture more leads with your profile, and a $200 credit to use on Justia marketing solutions. To upgrade today or learn more, you can go to pro.justia.com. Have a wonderful rest of your day. Thank you all so much for joining. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.